I will start with a brief overview of the procedural background of this evaluation. On 8 July 2022, the Commission sent you a request for submission of the 5-year declaration of assets and personal interests. And on the 14th of July, you submitted your 5-year declaration. The Commission also asked candidates to voluntarily complete and submit an ethics questionnaire, and you did so on the 4th of July. The Commission sent you 3 rounds of questions on 8 August, on 14 September, and 14 October. Your responses were submitted on 12 August in relation to the first round of questions, on 3 October in relation to the second round, and on 17 October in relation to the third round of questions. You were asked a total number of 38 questions, including 83 subparts, and 27 of the questions included a request for further documentation. You provided answers to 38 questions and 83 subparts, and you provided documentation in relation to 23 of the requests for such documentation. Please be advised that under Article 3, Paragraph 4 of the evaluation rules of the Commission, a candidate may not provide information, documents, or other materials during the hearing if the Commission requested these earlier and the candidate did not provide them within the time specified, unless the candidate provides sufficient justification for not providing the information as requested. Members of the Commission will now start with asking you questions. Nadezhda Rybczewski will start with asking questions, followed by Vitaly Miron and by Victoria Henley. We will try to keep our questions short and to the point. We ask that your answers be short and to the point as well. Part of the questions, as agreed upon with you, will be done in closed session pursuant to Article 12.2 of the Law number 26/2022. I will now ask Nadezhda Rybczewski to start with the first round of questions to you.
Thank you, Chairman. Bună ziua.
Greetings, esteemed judge. In the first round of questions, now will be about the compensation for the housing that you were to be provided by the state. In 2008, as a prosecutor, you won a case in court by which the Chișinău Court of Appeals bestowed on you the right to be given housing. So Chișinău City Hall and Chișinău Municipal Council were ordered to provide you with housing. This judgment, though, has now been executed for a period of 7 years. On the 30th of September 2008, you were appointed as judge. On December 30, 2012, on September 2nd, 2013, you applied to the Superior Council of Magistracy to be on the list of beneficiaries that would be able to purchase an apartment for preferential prices as part of the program managed by the SCM. In 2014, you received the apartment. On the 10th of March 2014, you concluded a reconciliation agreement with the Chișinău City Hall, following which, on the 5th of February 2015, you received a compensation of 1 million lei, about 1 million lei, for the fact that, well, instead of the housing that you were supposed to be given on the basis of the 2008 Court of Appeal decision. At the request of the Commission, you provided the copies of the reconciliation agreement and the report to establish the conditions of that reconciliation agreement, of the settlement agreement. You also stated that this agreement has been concluded with delays and was enforced with delay on the 5th of February 2015. The Commission asked you to provide the court's decision whereby Chișinău City Hall was ordered to change the way of enforcement, the 2008 court decision that has to do with awarding compensation instead of housing. And you answered that there has been no such court decision. Also, you told the Commission that you did not inform any authority about the pending enforcement of the 2008 housing-related decision, when in 2014, when you applied at that time with the CSM for an apportionment of preferential prices, because the decisions of the courts were public and the notification of the authorities was not among your obligations. You also provided the prosecutor office order of 9 September 2016 that provided for the refusal to start criminal prosecution against decision makers that allocated you the monetary compensation instead of housing as provided for in the 2008 judgment. According to that document, the bailiff initially refused to execute the settlement agreement, and you sued him on the 19th of June 2014 for inaction. On September 4, 2014, the Court of Strășeni District Court of Strășeni from Chișinău Municipality rejected your application, and that was upheld by Chișinău Court of Appeal judgment of 25 November 2014, which stated, among other things, that the Mayor General of Chișinău Municipality did not have the right to sign the settlement agreement without a decision of the Chișinău Municipal Council because its rights, the rights would have been affected by that transaction. However, the prosecutor concluded both court judgments were not relevant to initiate criminal prosecution because the bailiff accepted and signed on the 27th of June 2014 the records attesting the terms of the settlement. These are the facts, and on the basis of these facts, I will ask you several questions. First, we would like to confirm some of the statements, to confirm the factual description so far, and then you will have the opportunity and the possibility to provide further details if you find that necessary. Please confirm that on 26 August 2008, the Chișinău Court of Appeal ruled that the Chișinău City Hall and the Chișinău Municipality Council provide you, together with your family, housing on the basis of Article 38 of the law on the prosecution office that was enforced at that time in 2008. Right. Please confirm that in 2008, Article 38 provided the allocation of service accommodation, apartment or a house, for as long as the person worked in that settlement to prosecutors who didn't have a place to live or needed housing improvement. Potentially, I can't remember now what it provided. Please confirm that on 10 March 2014, you concluded a settlement agreement with Chișinău City Hall, following which on the 5th of February you received a compensation of about 1 million lei instead of housing. That's right. Please confirm that there was no court judgment to change the enforcement, the way of enforcement of the 2008 judgment. That was not even necessary. There hasn't been one because it was not necessary. Can you explain why it wasn't necessary? Because it was not, such a judgment was not asked for. By whom? By those who executed the judgment. What about did the Code of Civil Procedure provide for how the decisions are to be enforced? Well, potentially the Code of Civil Procedure provided for that. And the Code of Civil Procedure in 2008 did not provide that, where the way of enforcement of decision is changed, that is to be done through court judgment. Esteemed Madam, it was not my initiative. It was the initiative of the City Hall. In fact, they are the ones who made the suggestion to change the enforcement method. And it was not the enforcement method that was changed with regards to Osoianu only. But if I'm not mistaken, there were more than 100 people who this was applied to, if I'm not mistaken. And until that moment in time, in Chișinău City Hall, there's been about 4 or 5 assemblies with all of these beneficiaries, with all the creditors who were right there at that time on the lists that were to be enforced or that were to be applied those measures by Chișinău City Hall. And the next phase was about my right to go to the European Court for failure to execute, to enforce the decisions of the court. But how? In what way? I did not really care about it at that moment in time. The enforcement had to be in time, in due time, and in general. If we are to observe the law, these matters that have to do with ensuring, securing social rights, these used to be provided for in the law, then these had to be responded to within a year after one is hired on the job. And that was a duty of the local public administration body, and that was provided for imperatively in the law.
Please explain if, from your point of view, changing the way of enforcement of a judicial decision is legal without another judicial decision. From my point of view, it is legal, and that's why it was ordered to be enforced. So from your point of view, it was legal. Yes, a court decision was executed. Please explain. Article 38 provided for appropriation of dwelling, apartment or house. You accepted the monetary compensation. Do you think it is ethical to accept a monetary compensation instead of what was provided by the law? At that point, it wasn't about being ethical. I thought this was a correct step. And I still believe that. I understood that. Because the state had an obligation which it didn't fulfill. Please explain us why on 19 June 2014, actually before 19th, but initially, why the bailiff initially refused to enforce the settlement agreement, and you sued him for failure to act on June 19th. What was the reason? Why did the bailiff refuse? I don't remember. I don't remember which were his reasons to refuse to act. I remember that after the situation, he already invited me and provided me with a settlement agreement. You don't remember why he changed his mind and accepted it on June 27th? I think I attached all necessary documentation, including the transaction. So I attached. That's where the reasoning should be. We want to understand the motivation of the bailiff, if you remember. Well, that's what you should ask the bailiff. It should not ask me that. Please explain if Chișinău Municipal Council took part in negotiation and approval of this transaction. Yes, of course. Chișinău Municipal Council. The council. There were representatives of the council as well. Where were they? They gathered us in the ceremony hall of a municipality. It was a round table. Do you want to add anything? No, I think I explained things quite clearly in the first round of questions where I answered. I attached all confirmation documentation and I don't have anything to add. Thank you. Then let's move to the next block of questions. And this is about sources of funds based on which you purchased an apartment provided by SCM in 2014. So, on the 30th of December 2012 and 2nd of September 2013, you applied to the Superior Council of Magistracy to be included, and you requested to purchase an apartment at preferential prices under the SCM program. In your declaration of assets for 2014, you declared a mortgage contract with Basconslux and a debt of around 253,000 based on that mortgage contract. In your subsequent declarations for 2015 and 2016, you did not mention any debt related to the repayment of this loan. And in your answers to the Commission, you declared that the total cost of the apartment was 552,000 lei approximately. You attached a copy of the investment contract, including the payment receipt for repaying the loan. You also explained that you did not have any debts after 2014 since the payments for the investment into the construction of a dwelling space were made according to the repayment schedule established by the construction company. At the same time, in your annual declaration for 2014, you declared a loan of 270,000 lei from an unidentified individual. But in your answer to the Commission, you declared that that person is a close relative of yours Yes, and I sent you the identity. Yes, indeed you did.
Can we please slow down? I think our interpreters are struggling enormously from both sides, so please slow down a bit. Thank you.
You also declared that person in your 5-year declaration in the field of close persons. You explained to the Commission that you had the permission of the relative to use the amount of 270,000 lei in 2014, and you declared that you repaid this loan in full in 2015. According to the information available to the Commission, the respective individual during 2008 to 2016 had numerous crossings of the border, state border. But that is all the information that the Commission has available. You did not provide any supporting documents proving the income of that person abroad or the source of the money in order to be able to give you the 270,000 lei. In this context, please confirm that you told the Commission that that you borrowed the amount of 270,000 lei from a relative of yours to cover the costs for the investment contract. And you mentioned that in your speech, if you heard when you read it, you said that I did not borrow, and I explained it below and with the other amount. This person is an uncle of mine who during that time was working to earn money in the Russian Federation. So, because of some family circumstances he had at that time, the money he was earning, he asked me to keep it. I was keeping his money. I had free access to his money, to those funds. And in the moment when I had this issue that I was accepted to at least to pay in installments to have a contract with Basconslux company, I asked permission from him to use the money to the extent that I need in order to purchase this apartment. Moreover, I told him that I will purchase this apartment, and if there is a situation to sell that apartment, and if we earn money on that, then I will give money to him as well. Meaning if we make profit. Do you understand what the discussion was? In the end, it didn't happen like that, because I personally live in that apartment. Until today, I did not sell it. I did not do anything. But initially, you purchased it with the idea to sell it? Initially, I took the money and I told him, in case if I can't repay you, in case if there are difficulties, we will sell it and you will actually earn something from this. I understood. Please now, in this context, esteemed lady, I won this case against the City Hall and I managed to cover my expenses. We are not asking you about that. The question is if you can confirm that you presented no justification about the income of that person. And if you can explain why. He was working informally in the Russian Federation like everyone. I don't think he had an official employment contract. So he certainly did not have one, because he worked in Moscow for some time, then in St. Petersburg. So I mean, he was moving back and forth from one city to another. And I also went to work in Finland, but also through that part. You used to be a judge at that time. Which year are we talking about? 2014? Yes, indeed. As a judge, when someone entrusts you money, if you take a loan, don't you think it is correct to conclude a contract about an agreement about it? He was my uncle. He brought me up. I was staying with him when I was a child, a student, and he trusted me. What kind of agreement are we talking about? And all the money he earned, he left with you with no proof. All the money he left with me. I kept all his money and I reimbursed him all his money. Moreover, at that time, part of that money, a bit earlier, was also placed with the bank. Do you have any information? That was my following question. Why didn't you keep it in the bank? Well, he was disappointed because he placed a bigger amount, but when he got it back, it was a smaller amount. Do you remember what bank we talk about? If necessary, if I'm not mistaken, it was either Moldinkom Bank or Moldova Agrarian Bank, something in the center, because I remember, because I went with him there, and that was somewhere back in 2006, 2007 maybe. So now we talk about the money you borrowed in 2014. I had free access to it. I did not borrow. I just asked permission. So you kept it in cash? Yes, at home. Well, he brought it and I kept it as it was. Moreover, I think, yeah, that was it. I have no more questions about this topic. Would you like to add anything? No, you described everything in a lot of details. Thank you. Thank you. Mr. Osoianu, I would like to greet you as well. And sorry for hesitation maybe, or my colleagues, but I have some questions of clarification on the first topic about the settlement agreement. And I want to ask questions to make sure that I understood your position about the topic. Two questions, actually. The first one. According to the Enforcement Code Article 67 that was applicable in 2015, there was an explicit provision about changing the way and order of enforcement. And the provision says that if there are circumstances that make enforcement difficult or impossible, the bailiff or the parties to the enforcement process shall go to court that issued that writ of enforcement a request to change the way of enforcement. Previously, you declared precisely, or you said that it wasn't necessary to get such an additional decision on changing the way of enforcement. Please confirm it once more if you support that position. I support my position because if such a decision would have been necessary, then I would have asked for this change of way of enforcement. Okay, we received your answer. Second one, you mentioned that as a creditor you were invited repeatedly, you said that to the round table at Chișinău City Hall, where you had discussions about the possibility to enforce the writ, being a creditor. And you mentioned that there were several people invited there. And in this context, I have a question. From open sources, at least I know that there is a lot of writs of enforcement, similar ones about providing housing. Some of them are like decades old and they were not enforced because there is no available housing space. So at that time, when the settlement agreement was concluded, there were accepted a limited number of writs of enforcement for those transactions, including yours, because you were part of that procedure. Could you explain, or do you have any reasoning, what was the criterion for which your writ of enforcement was accepted to be enforced in this formula? I explained it wasn't only me there. An order was established there in chronological order, as you are saying. These writs that were valid, or they were included for enforcement at that time. And such a suggestion came, and bailiffs dealt with that. I cannot explain why I was first and you were second, or you were first and I was second. I have no explanation of that. I suspect there was a chronological order. Okay. Actually, we received your answer, but I'd like to reiterate to be sure. You don't know why. You just suspect that it was in chronological order. Is this your answer? Yes, I think Well, there were bailiffs. There were many bailiffs, actually. And they discussed, I cannot give you a firm answer. Was it chronological? There was a list with the City Hall. There was a list with the City Hall. And based on that list, the mayor promised that according to that list, I will do my best for all writs of enforcement to be enforced or will arrest. And actually, I think I held the mayor to administrative accountability twice. I went to court, complained for failure to enforce court decision. But all creditors do that. I'm telling you what I did. I don't know if all do. I did. Last question. And sorry for interrupting you, with all due respect. There was a list, certainly, and based on that list, every bailiff, at least bailiffs had a list, certainly, something about how it worked. Mr. Osoianu, I received your answer, and I would like to discuss another topic now. Hello, Mr. Osoianu. At this moment, in 2008, you were a prosecutor. 2008, sorry. At the moment when law on prosecution provided for the obligation of public authority to provide the prosecutor who had no dwelling with a service housing. By court decision, you were allocated permanent dwelling, permanent housing. The court decision was challenged with the Supreme Court, and the City Hall filed for this too late, 5 months later, and the decision stood. That's a fact. And after that, you insisted on the enforcement of that decision. What's your position? Because at that time, the law was providing for having the prosecutor getting from the state, represented by the local authority, job-related or a service housing, and the court passed a decision to give you permanent housing. What's your position on that? Thank you. Then, esteemed judge, at that time they made reference not only to the law on prosecution, but also to the housing code and other legal acts that were relevant at that period of time. I cannot tell you precisely what was the ruling part of that decision. I don't have it now, the ruling from the Court of Appeal, but my position, that then I reached my purpose. That's what I aimed for, to have housing. To me, it was it didn't matter what status that housing would have, and I think that most judges who worked in that period of time got housing, and then they went for privatization and privatized. I'm speaking of a prosecutor, because it's all prosecution. Prosecutor is the same. Also, the law and status of judge had different provisions than law on prosecution. Thank you. So, to continue our procedure, let's try to tackle another topic, Mr. Osoianu. I will start by describing the state of things, and then I will ask some clarification questions, and I hope, well, they are written in a way that you can answer briefly to them. We talk about the land plot that you requested and received in Strășeni City. According to the decision of Strășeni Municipal Council of 24th of August 2017, you received 0.07 hectares in Strășeni. According to your declaration for 2019, the land was acquired through title authentication, the rights of a landowner, on 10th of April 2019. You provided the Commission a copy of the decision of Strășeni City Hall. You told the Commission that you submitted the application to get the land plot and to the City Council in the years 2010 and 2011. You stated you don't have copy of those requests, those applications, but you provided an answer on from Strășeni City Hall that they responded that at that moment they could not provide you housing, and as to the request of allocating you a plot for building a house, it would be sent to Strășeni City Council for examination. You have told the Commission that the legal basis for requesting and receiving the respective land plot is the law on local public administration. The regulation on allocation of parcels within the locality of Strășeni and Făgureni, approved by the decision of the City Council 5/32 of 9th of October 2016, Housing Code, Land Code, and the law and status of the judge. You also stated that the legal basis is, well, all these legal reasons are mentioned in the decision of Strășeni Council passed on 24th of August 2017. So you confirm that you did not pay any money to the authority that awarded the land plot because it was granted under Article 11 of the Land Code. Subsequently to your answers, you also declared that since 2010 you were provided with service-related accommodation according to Article 30 of Law number 544 on status of a judge. All supporting documents at that time were attached to the initial application you submitted. Subsequently, Article 30 of Law 544 was repealed, reason for which you submitted an additional application invoking the provisions of Supreme Court of Justice recommendation number 3 of 1st of November 2012 regarding the applicability of Article 30 of the law on the status of a judge regarding judges who at the time of repealing of that rule were not provided with housing in light of Article 267 of the Civil Code. So, in conclusion, you stated that you submitted a number of applications requesting the allocation of a land plot to construct a house in Strășeni. So you applied to the City Hall because you did not have housing at that time and you insisted on this until they accepted. You also stated that in 2017, when you got the land plot, you already had a family, and that's why Article 11 of Land Code was applicable. According to the information available to the Commission, you said that you did not build any house on the allocated plot, and that plot is still your property. At the same time, according to the information available to the Commission, you registered under your property a land plot of 0.06 hectares in Strășeni village of Chișinău municipality that you obtained through a sale purchase contract in 2019. The declared price of a land plot is 150,000 lei. In your 2021 declaration, you declared the construction 160 square meters house, 50% degree of completion, and an investment and service provision contract worth 800,000 lei for the building of a house. So please confirm, Mr. Osoianu, that on August 24, 2017, you were allocated 0.07 hectares land plot in Strășeni, thanks to a decision passed by Strășeni Municipal Council on 24th of August. I do confirm. Please confirm that in the mentioned decision, the following legal grounds for allocating the land are mentioned. Article 14, paragraph 2 of the Law on Public Administration, Article 11 of the Land Code, and the regulation on method and allocation of land plots on the territory of localities for building houses in Strășeni and Făgureni, approved by the decision of the City Council on October 9th, 2016. I do confirm. Please confirm that you told the Commission that you submitted the first application to get the land plot back in 2010-2011, based on the legal provisions requiring local public authorities to provide judges with accommodation. Yes, if they had no housing, service housing, they should be offered land plot for constructions. At least this was my first application. Well, based on the answer from Strășeni City Hall that you received, that was read before, could you please explain? At the time when you filed such an application with a local authority, did you, well, what did you ask for? Housing, land plot for construction, or did you ask both? I asked for housing, service housing, and in absence of such, to get a land plot for construction. To make it clear, you asked housing, and if that's not available, to get a land plot. Yes, something like that was written in the application. And from the answer of City Hall, that should be clear. I did not find the initial application. Please confirm if you ever challenged in court the inaction of Strășeni local authorities to provide you with housing or land plot, or for not answering you within the deadline, within the timeline provided by law to respond to citizens' petitions. No, I never challenged it, even though it took 7 years for them to look into your request based on our estimation. So if you look, it started in 2010 and the decision was in 2017, it's 7 years. They were informing me regularly that they will look into it, they will satisfy my request at the time when it's appropriate. I don't know, I did not challenge it. But you provided to the Commission only one answer from Strășeni. Probably that's the one that I kept. Maybe there are others. It was August, I was busy at that time of the year to find all the correspondence with the City Hall. But the mayoralty should have the file on this. Mr. Osoianu, please confirm that in answers to the third round of questions, you told the Commission that since you were not provided with housing, you kept submitting applications to Strășeni City Hall to get a plot for construction until they finally accepted it. In the meantime, you created a family, and the legal foundation was now Article 11 of the Family Code. Yes. Sorry, it was Land Code. Yes, Land Code. Article 2 of the Law on Youth. Provisions of Article 2, I think, of the Law on Housing. There is a provision about the notion of family. I cannot be precise, I don't remember exactly. Only to clarify and to understand your position regarding this topic. The provision under Article 11 of the Land Code has two actions about allocating land plots to individuals. Allocating a land plot under building and giving a new family a land plot from the reserve of a territory of a local authority until it is, as long as it is available. So related to the decision of a local authority saying that that land plot was allocated to you from the reserve that the City Hall had. So do you insist that this was the reason? Yes, yes, this was the reason. It's an existence of a new family. But at the time when you filed your request in 2010, 2011, at the time when you obtained a favorable decision, were you married? Yes, I was married. For clarity and for our minutes, when you filed, so you're talking about 2010, 2011, and when you obtained a favorable decision from the local authority. At the moment when I filed to get service housing, I was not married or asking for a land plot. When it was satisfied, I was married. I already had a child, if I'm not mistaken. That was 2017. Who accepted your answer? Please confirm if at the moment when the land plot was appropriated to you in 2017, you owned any real estate that required improving living conditions in the mentioned settlements, Făgureni and Strășeni. I did not own any real estate. Please explain if allocation of a land plot for construction of a house was covered by Article 30 of Law 504 when you filed the application to allocate a land plot back in 2010-2011. Once more, please, I did not understand. Please explain if allocation of a land plot for construction was covered by Article 30 of the Law 544. And Article 30 did not provide for land plot only about service housing.
In your answers, in the third round of questions, you told the Commission that you've also looked into the recommendation of the Supreme Court of Justice, number 3 of November 1st, 2012, as an additional legal basis for requesting an immediate provided land plot. And that recommendation has to do strictly with housing, not with land. Please explain what did you mean in your answers, and what is it that you wanted to tell us through that message? What I annexed, the recommendation, I mean, if you use that as a legal basis. So what did you mean? You asked for documentation for the correspondence that I engaged in with the local administration body, and I've annexed all the documentation in that regard, including the in the package of documentation. There was this recommendation as well that you referred to that I initially filed in 2010, and that's why I think I put it in the folder of documents that I sent you. Oh, that's all I can say, nothing else. But it doesn't provide for why did it have to be annexed if it's not a legal basis for being provided land? I don't know. I annexed it because it was there in all the folder with the documents all at once. And if it's not valid, if it's not relevant, then you can give it back to me. Fine. Please confirm that in 2017 that land was appropriated to you for free. For free, but I only had to pay a fee for some land planning activities. There was some symbolic fee that had to be paid, though. Now, looking back, Mr. Osoianu, could you model for us, could you tell us how over time the legal bases have been changing that supported the allocation of that land, as in what applications were filed, what documents were submitted? Now, looking back in time, chronologically, what was the situation? I was quite clear in the answers that I provided to you. In that same context, please explain what measures did you undertake since you acquired the title of authentication of the right of landowner on 10 April 2019 in order to initiate a construction of a house following the purpose for which that land was attributed thus. On that land plot, I did not undertake any measure whatsoever so far, because I had a favorable offer elsewhere, and I purchased a land plot in a village in Strășeni, and I initiated the construction of a house there. So, clarification, in Strășeni, did you say? Yes, the village was in Strășeni, but then the Strășeni is now a suburb of, that village is part of the Strășeni municipality, but it used to be a separate village per se. Now it's part of a municipality. Please confirm that in 2017, when you received the land plot, you were already an owner of an apartment in Chișinău purchased as a preferential price due to your position as a judge, according or under the program run by the SCM. Yes. Do you confirm that in 2017, when you received the land, you had already received the compensation instead of the housing by a decision or on the basis of a decision of the Court of Appeal and the settlement? On the basis of the settlement, and the answer is yes. Please explain if you informed the Strășeni local authorities that awarded you the land plot in 2017 that at that time you had already been awarded a compensation supported by the settlement agreement, and that you cumulatively had become an owner of an apartment in Chișinău bought at a preferential price on the basis of a program conducted by the SCM. I did not inform them because I did not think that I had to. No. And this is in the media since back in 2015, since the method of execution of enforcement has been changed, and everybody knows this is out there, and everybody knows, and now attention has gone back to this. In your perception, at the end of the day, do you think you had the legal right to receive the land plot in Strășeni in 2017? Of course. Of course. Do you think it is ethical for you to receive a monetary compensation on the basis of a settlement transaction, a preferential price apartment, and a land plot, all based on the right to be allocated accommodation? Yes, I think it's ethical. Now, considering the complexity of the matter that we addressed, is there anything that you would like to add, anything in addition that you would like to provide? No, you were very thorough in your accounts. Thank you for the answers that you provided. Mr. Osoianu, Chairperson, I do not have any further questions.
Good afternoon. I'm Victoria Henley, and I have some questions to ask you about automobiles. And the first has to do with, in your declaration of assets for 2014, you declared the sale of a model Mercedes-Benz E220 for 140,000 lei. In your declarations for the years 2012 and 2013, you did not list the car. When you were asked by the Commission why you had not declared the Mercedes-Benz during those years, you stated that you did not declare the car because you were not obliged to do so, as the car was purchased in 2009 or 10, exactly when you didn't recall, was imported from abroad, and at that time in the declarations on income and property, you declared only the goods purchased in the declared calendar year, not the goods that were already owned. You told the Commission that you did not have a copy of the sales purchase agreement. In your declaration for 2009, you declared the car model Mercedes-Benz E220, imported on June 22nd, 2009, with a declared value of 140,000 lei. According to Article 4, Paragraph 1, Subpart B of Law Number 1264/2002, applicable for declarations between 2012 and 2015, declarants were obliged to declare movable and immovable property of all kinds owned by the declarant or members of his family on the basis of contracts of mandate, commission, fiduciary administration, and translational contracts of possession and use at the date of submission of income and property. Please confirm that you purchased a model Mercedes-Benz E220 in 2009?
No, I do not confirm that I purchased it in 2009, and in general, I did not buy any Mercedes. I think there is a mistake or some confusion. This car belonged to my partner, and this car was declared as an asset belonging to my partner. And if I'm not mistaken, in 2015, 2016, or 2017, or it was either declared by me by mistake 2 times in a row. This car was purchased in 2015. There was something like that. The car does not belong to me. It's actually registered in the Transnistrian region, and my wife is from there. So she was the owner of the car, and I declared only what she declared to me at that moment in time. She had the obligation to declare it to me, then I declared it myself. And then this car was sold, if I'm not mistaken, in 2019 or 18 by her, though it was being used in the Transnistrian region by the person that has purchased the car. I never even saw this car in my life.
However, you did declare this car as owned by your partner in 2009?
No, in 2009 I couldn't have declared it. In 2008 I did not have a relationship with her. My partner, I had just my future, so to speak, partner. I only met her in about 2012, 2013. That's when I met her, even, if I remember right. So I think there's some confusion there. In 2009, I don't know, it was a car. No way. I think there's some confusion. There's some confusion there. We can look into the declarations. And in 2019, I sold the Honda, and in 2014, I purchased it. But there must be some confusion here about it. It's not mine. I never had such an asset in my possession. This is an asset related to the Transnistrian genre. I never have I ever seen it. And when it was sold, I was told about it, and there was the money, and that was all.
Okay, but
And it was not even me the one selling it.
I believe the Mercedes-Benz you're referring to that your partner owned and that you registered was a Mercedes-Benz S400, model year 2000?
I declared it because she declared it to me because we were together. We lived together in 2016.
And there was also, though, a Mercedes-Benz.
Maybe even you might see declared in 2017 because by mistake I declared it 2 years in a row, but it was not purchased. I mean, it was purchased only once, not 2 years in a row. But better than now hopping around it.
For this car,
Yes.
we have the copy we can present. It's the third issue. He's talking about the partner, but our question about is his car.
It's the E320,
Yes.
the E220.
Yes. Yes. Domnul Osoianu, doamna v-a
Mr.
întrebat despre
Osoianu,
mașina pe care dumneavoastră
You were
ați
asked about
declarat-o,
the car that you
pe
declared.
care dumneavoastră ați declarat-o în
The car that you
2014.
declared in
Este vorba despre
2014.
Mercedesul dumneavoastră.
It's your
Puteți mai întâi
Mercedes.
să vă referiți la asta
Can you
și
first
după asta,
tackle this,
Victoria va continua
and then
cu
Victoria
întrebările
will
despre
continue with a
mașina
line of
cealaltă.
questions about the other car of the partner.
Deci, ceea ce doamna v-a
So
explicat
what
până
you
acum,
were
doamna
explained
Victoria.
so far. So we're not talking about my
Este vorba
partner's
despre
Mercedes.
Mercedesul
No,
E220.
we mean
Doamna, despre asta vă întrebam.
E220. That's the model. I never had such a car either, but you declared in 2014. 221, maybe, I mean,
Bine, ați avut un
fine,
Mercedes
you
pe
had a
care l-ați vândut
Mercedes
cu
that you
140.000
sold for
lei.
140,000, did you?
Despre asta este
Yes, I
întrebarea.
did. Fine, that's what the question is about. So why do I have to do to confirm? Yes, but let's maybe resume. It's
Is there some confusion or was there a mistake made as to the model of the car?
the model, and if I'm not mistaken, I wrote it in the answers and the registration plates, because the plates of the car that you had was one that was not even out available to take one. So there was such a car that I bought, sold by myself in 2009. Or 2010, no, in 2009, I bought it in 2009. Yes, that is correct, Nadezhda. In 2014, I sold it. Yes, that is right, that is true.
He has the facts.
Yeah, let's confirm that in your declaration for 2009, you declared the purchase of the Mercedes with the declared value of 140,000 lei.
Now I don't remember. In 2009, the money that I bought it for, I can't remember. But I know that I sold it for 140,000 in 2014. That Mercedes was sold for that
And I think
amount. Here is I found the declaration.
If you allow me, Victoria, 1 second. Dear judge, could you look at, stimate judecător, puteți să vă uitați
Esteemed
în
judge,
fapt
could
la
you
pagina
look at the
4
facts?
dumneavoastră,
Page
aveți
4,
faptele descrise, pe
There's
care
the
le-ați
factual
descris. Este
description
vorba
that
și
we
este
refer
corect.
to. So
Așa cum
it's
a spus
right.
doamna
The way
Henley,
Madam
vorba
Henley
despre
stated it, it's
Mercedesul
right. It's a
Benz
Mercedes-Benz
E220.
E220.
Așa le-ați declarat
That's the
dumneavoastră.
way
Dacă ne
you
permiteți,
declared
vă
it.
spunem numărul.
We
Pentru
can
motive,
tell you the other
protecție.
details, but for personal data reasons.
2014.
I declared it, well, I mean, in your answers that I provided to you, in your 2014 declaration. I'm looking at my declaration right now. E220, there's nothing. Osoianu, Mercedes-Benz. Here, have a look at it. This is my declaration. And nobody altered it. 2014. Have a look at it. And the amount. It's all there. Osoianu Sergiu, it says. Contract. There's even the contract put down here. Contract on the sale of Mercedes, 140,000. Yeah, this is what we're talking about, but there's nothing else here. I'm just telling you what it was, what this was about. It wasn't 220. If I ever provided this in my answers, I might have made a mistake. But you had such a car. I did. That is correct. So you're not contesting that. And in your declaration of 2014, you declare that you have sold it for 140,000 lei. Yes, that is the amount as provided for in the contract. That is correct. But you saw it. You just saw it for yourself. Madam Victoria.
And please confirm that in your declarations for the years 2012 and 2013, you did not list the car?
2012, I might not have, because I hadn't purchased it at that time. According to the law, you were supposed to, according to the law in place at the time, you were supposed to declare the assets you purchased in that calendar year that you were reporting for. So I did not hide it away. I declared it in the declarations where I had to declare it. But let me have a look. 2013 is there, but I mean, the car did not appear in all the declarations. It only the assets that were bought in the reporting period, only those assets had to be declared. And it was not like now there's a new model of declaration, so maybe that is different. But let me have a look at it. It's not there in those years. It's not there in those years. In 2012, I don't see it, and 2013. 2012, no. 2013, no.
Correct. And let's just confirm that the reason that you informed the Commission the reason you didn't declare it was because you didn't think it had to be declared except in the year it was purchased. Okay.
Right, that is right. That is right. That's what I said.
And please confirm that you also told the Commission that you didn't have a copy of the sales purchase contract for when you acquired the car in 2009.
I don't think I bought it, because I did not even buy it. I mean, actually, I was given at the customs. I was transferred this car at the customs, so I did not have such a contract in 2009. Sorry.
Okay, and please confirm that you sold the car in 2014 for 140,000 lei.
Yes, that's what happened. That was the price back then.
Okay, and can you explain how you were able to sell the Mercedes-Benz 5 years after you purchased it for exactly the same amount you paid for it?
I can explain, because when I bought it, I paid a smaller price and I was happy about it. But it had been used for taxi services. So abroad, it has been used by taxi drivers for taxi services. And therefore, the mileage was very big. And it turns out that I had to spend a lot to repair it, and then I had to sell it because it was just not quite operational. It had a lot of issues, very serious issues. All the time, there was something wrong with it. So it was like a second-hand car already used by somebody else before that. So it wasn't something good. I mean, many Moldovans have had this situation like me, those who buy cars from Europe, that is. So it wasn't me alone. Especially previously, these Mercedes cars, this was specifically typical of Mercedes cars bought from abroad. So there's nothing out of the ordinary here. That used to be the price back then. And you even had to find someone to even buy it for that money. I think the person who bought it sold it, then further used it for the parts of this car. That's why they bought it even. Because when I filled in the declaration, I tried to look into it because I sold it on the basis of a proxy of an affidavit. So I wanted to even see if that car is around in the country and whether all the documentation was filled in properly, so that I didn't have any problems with the declarations. And then I found out that the car was not even existing, so to speak, in Moldova. It means it was sold for the parts further on, like dismembered, disassembled, and sold for parts further on. It was not a good car that could have cost bigger amounts of money.
And I think you indicated that the car was not operational when you sold it?
No, it was operational, but it was there was a lot of wrong issues about it. It was problematic. It had been used for taxi services, and that's why there were always problems with it. And the person who bought the car, who I gave the rights over that car to, that person has acquired it for its parts.
Okay. Is there anything further you'd like to add?
That is an average, ordinary procedure in Moldova. If you bought a car that is not the best car out there, then if you have nothing to do with it, repairing it is expensive. So I was forced into selling it. So apologies, Madam Victoria.
Have follow-up question on this particular car. Yeah, okay. Then we'll go on with it.
I just want to, for the record, pentru a confirma, domnul Osoianu,
Just to confirm, Mr. Osoianu, this is the copy of your declaration in 2014, where we can see clearly that is exactly the model that Victoria Hanley named. And in the questions, in the correspondence with the Commission, you did not disagree with the model and you did not highlight any mistakes in the name of the model of this car. This is my number, my plates, the plates of my car, but maybe this is something, I mean, E220, I thought it was a different one. Well, I apologize. It says here, it says 220. It doesn't say that in my files, and I don't know what is the reason for this. I confirm that it was E221, not 220, but 221. It must have been an accidental omission. But that car does not exist anymore. It's nowhere to be found in Moldova.
Right. Let me ask you now about a Honda CR-V. In your asset declaration for 2019, you declared income of 177,030 lei from the sale of a car model Honda CR-V, model year 2007. In your declaration for 2014, you indicated that you purchased the car for 150,000 lei. Thus, according to your declarations, you sold the Honda CR-V 5 years after purchasing it for 27,000.
The comment was that the person couldn't hear me well, so... And now the candidate confirmed that they can hear the interpreter well.
Okay. According to your declarations, you sold the Honda CR-V 5 years after purchasing it for 27,030 lei more than you paid for it. Currently, similar models to the Honda CR-V, which you purchased in 2014 for the declared purchase price of 150,000 lei, are listed now at around the equivalent of 191,000 lei. In the first round of questions sent to you about this car, the Commission asked you to provide a copy of the contract of purchase in 2014 and the contract of 2019 when you sold the car. In your response, you indicated the sales purchase contract was attached. The document the Commission received was blank. You were asked to present copies of both the 2014 and 2019 contracts. In response to the Commission's third round of questions to you, you attached the copy of the 2019 sales purchase agreement, the one that pertained to the sale of the car, and declared that you do not have the 2014 purchase agreement for the Honda. When asked by the Commission about why you were able to sell the car for more than you declared that you paid for it, you stated that at the time of purchase, the car was in damaged condition, for which there were repair costs, and therefore the price of the car increased to that price indicated in the sales purchase contract at the time of its disposal. You did not submit any confirming documents regarding the claimed repair work you carried out for the car. And you did not file a Form CET 18-2019 with the Fiscal Service and paid no tax on the income you received on the sale of the Honda. When asked by the Commission why you did not file an income declaration and pay taxes on the income you received for the sale of the Honda, you stated that you did not do so because you did not have an income from the sale of the car, as you had incurred additional expenses for the repair of the damaged car. In addition, you told the Commission that you were entitled to submit a declaration within 6 years of the time when you received a certain income, and that you would consult with employees of the tax service about this matter. Please confirm that in your asset declaration for 2019, you declared income of 177,030 lei from the sale of the car model Honda CR-V model year 2007.
Yes, I confirm. I confirm I declared revenue out of the sale of the Honda CR-V car.
And please confirm that in your declaration for 2014, you indicated that you purchased the car for 150,000 lei.
Yes, well, what I put down in the declaration at that time, that is the amount that was concerned. That is true.
Okay, and please confirm that according to your declarations, you sold the Honda CR-V 5 years after purchasing it for 27,030 lei more than you paid for it.
Yes, I confirm this. And I would like to add to this, to communicate to you, Madam Victoria, that in addition to the repairs, I've also installed a gas facility for fuel. And that was also reflected in the vehicle registration certificate. I do not have access to that certificate. I need to find the owner, the current owner, the person that I sell the car to. But that's what happened. So in addition to the repairs, the technical part, I've also installed this equipment so as to be able to fuel the car, to use gas as fuel for this car. So that's what made the price bigger. And I've also, when I bought it, there was a relative of mine that found this car and showed it to me. It was a car that somebody was selling it as a matter of emergency. I did not have a car at that moment in time, so I bought it.
And when you purchased the car, what was needed in terms of repair of the vehicle? What was it that...
Well, back then there were a number of issues. So there were some technical matters where the car was taken to the car service. Some changes were changed for the technical parts of the car. There were other parts that were purchased, and then I've also, as I said, installed that equipment to be able to use gas as fuel for the cars. So that was more or less the issues that had to be fixed. But there's supposed to be, the new owner is supposed to have this technical card that should say what amendments or what changes were made, as in that there's a gas supply system installed on the car.
And what was the cost of the gas supply system that you installed?
Mr. Osoianu, can you please bring the microphone a bit closer to your mouth because it's difficult to hear? Yeah, thank you.
Esteemed Madam, had I known that these questions would emerge and that I would be interrogated like this in the commission hearing, maybe I would have come prepared with an answer to this question. At that time, I didn't have any interest in keeping all those documents. Maybe this documentation is somewhere there, reflecting the cost that I've incurred, but I can't remember now well. I can't remember how much I paid. Installing the equipment for gas, I think not less than 15,000 lei. I think that was the price, if I'm not mistaken. Or maybe, I don't know, because I was not the one directly dealing with it. It was that relative of mine that dealt with all this thing of installing that system.
And was the car drivable when you purchased it?
It was operation drivable when I bought it, but it had a serious defect with one of its parts. I don't know how to call it. I mean, when you drive it, you would hear this weird sound. So there was a weird sound when you were driving it, though it was movable, drivable. But this was the most serious thing, and there were some other renovations as well, but this was the most important part, that there was some weird sound coming out of the car when I was driving it. And one more thing with regards to this capital gain, I've actually, by the way, paid the capital gain tax. So this is a matter that I addressed.
I heard what he said. And when was the capital gain tax paid?
I paid for the tax for the capital gain on that amount of 30,000 lei, up to 30, was it 27,000 something. So I improved my emission. I corrected it about this capital gain. Recently, yesterday or the day before.
Okay.
I recently paid it.
Did we get the date on the certification?
25 October 2020.
Okay.
Sorry, 2022. So 2 days ago.
All right.
Yes, 2 days ago.
And is there anything else you would like to add or further clarify with respect to this vehicle?
No, I think that's all.
Lastly, I'm going to ask you some questions about what I think we've already referred to as the Mercedes-Benz S400 model year 2000 that was owned by your partner. And you declared ownership of that car in your annual declaration of assets for 2016 and 2017. In your declaration for 2019, you declared that your partner had income of 196,700 lei from the sale of what was an unidentified car. When asked by the Commission what model car had been sold by your partner in 2019, you stated that it was a 2000 Mercedes-Benz Model S400, which she had obtained on the basis of a power of attorney issued by the authorities on the left side of the Dniester, and that no sales purchase contract was signed. At the same time, in your annual declaration for 2016, you indicated in the column regarding how the car had been acquired that it was acquired based on a sales purchase contract year 2015. You also told the Commission that following the sale of this car in 2019, no income statement had been provided to the tax service for the purpose of paying capital increase tax, as your partner did not receive an income from the sale of the car. You also stated that, moreover, quote, moreover, this transaction had taken place, quote, in the area of the self-proclaimed Dniester Republic, end quote, you did not provide any documents in relation to this car. Please confirm that in 2015, your partner purchased a 2000 Mercedes-Benz S400.
If I wrote that in my declaration of assets, that's it. I confirm it.
Okay. And please confirm that your partner purchased this car based on a power of attorney issued in your own words, quote, by the authorities on the left side of the Dniester.
I cannot confirm. I don't know what was the way that vehicle was purchased. That car, I don't know. I don't have the necessary information about it. It was from Transnistria. What year is the declaration? 2015? No, for 2016. Yes, indeed. So I see it was sold. Well, it's a sale purchase contract. Yes, it says it's a sale purchase contract. It means it wasn't based on power of attorney. Oh, sorry, not on proxy. it means there was a contract about it. If it says that there was a sale purchase contract. It wasn't based on proxy, she wasn't using it.
But I believe you indicated when you were asked by the commission about the car, you indicated that it had been sold pursuant to a power of attorney and that no sales purchase contract was signed.
Well, I also asked her this question. She went to Transnistria twice to sell a car, in 1 year and then another year. And if, well, I believe she concluded a sales purchase contract. If I declared it, it means I consulted her when I declared these things to the commission. Since I declared that to the commission, that it was based on power of attorney, it means that's how it should have been. I don't know.
Okay, but I believe in your declaration, your annual declaration filed in 2015, you indicated that there was a sales purchase contract, but when you were asked by the commission about it, you said that there was no sales purchase contract, that it was done pursuant to a power of attorney.
I think it was sold based on power of attorney. But in my 2015 declaration, I couldn't have said anything about the partner because I had no connection with her property in 2015.
Domnul Osoianu,
Mr. Osoianu, maybe it's an interpretation issue, or please focus on the questions that Victoria is asking you. The question was the following. In your declaration of assets for 2016, well, now you're saying 2016, but it was told 2015 to me in the... Let's confirm. In your declaration for 2016, you declared that this car was purchased by your partner based on a sale purchase contract. This is written in the declaration I have in front of you. If it's written like that, it means it is like that. Subsequently, you were asked in answers to the commission in round 1 of questions, and I quote exactly what Victoria said. Sold that model car, year of based on power of attorney issued by authorities in the left part of Dniester River. Yeah, so possible. No, we have 2 answers for you. One in the declaration and one that you wrote to us. And this is what Victoria was asking. What did I write in the declaration? You said there was a contract. Sales purchase contract. Please understand, this is what my partner told me. I may be mistaken.
Round 1, question 7.
Maybe contract, maybe power of attorney. I am not sure of this answer. What I mentioned in the declaration probably is the right thing. What I wrote to you, maybe I was mistaken. Maybe I had several discussions for 2019. Sale of a car. Sale of a car, but I don't see it written until the end of the declaration.
In 2015, it's the purchase.
Anyway, in 2019, she sold it. According to my declaration, I see she sold it in 2019. The car.
Okay. When your partner purchased the car in 2015, did she pay for the car?
I think so. Probably she did. Otherwise, how could have that happened?
Right. And so if so, how much was paid for the car?
I don't know. I don't know how much she paid. So 2016. I don't know. I can't say how much he paid. I don't know the amount. Probably also around 10,000 euros, something like that.
And please confirm that your partner sold this car in 2019 for the declared price of 196,700 lei.
Yes, she declared that. It means that happened. At least this is what she told me.
And when you were asked by the commission about whether your partner had submitted tax declarations for paying taxes for the capital increase, you said that she had not, and stated that she didn't submit tax declarations for paying taxes, and you said, quote, moreover, this transaction had taken place in the area of the self-proclaimed Dnestr Republic. Could you explain what that had to do with not paying taxes?
She did not make income out of that. She sold it for as much as she purchased it, something like that. Maybe she even bought it a bit more expensive, so there was no capital gain in this respect.
And when you declared the sale of the vehicle in 2019, you did not include the specifics, the model, year of manufacturer of the car that your partner sold. Was there any reason that information was omitted?
In 2019, I included everything that was required here in this section. As far as I remember, maybe I omitted something. I think you gave that to me. What wasn't included about that car? I don't understand. What was not mentioned?
Model, year of manufacturer.
I see even the name of who she sold it to. Alexandra Sienko. Well, what she declared to me, I declared. It's the same car that was mentioned in the declaration of 2016. There was no other car. So there is even no such section there to mention.
Can you please use the microphone again a bit closer to? It's very difficult for people in the back of the room.
Sorry, there is no such section to write under income the model and other details that are characteristic of the vehicle.
Do you have anything additional you'd like to add or further clarify with respect to this car?
No. No, I don't. I just want to understand, Mr. Osoianu. You confirmed today once more, and in the written answers to the Commission, you said exactly the same thing. In 2019, your partner did not file any tax return to pay for capital gains because she did not gain anything. At the same time, you said, in our written communication, you said you did not know how much she paid in 2009 when she purchased that car. So please just explain, how do you make the calculation that she wasn't supposed to pay a tax in 2019 when she sold it, since you don't remember how much she purchased it for? Or you don't know? From her explanation, she sold it for as much as she purchased it, meaning there was no gain. That's what I declared. And I think in the declaration of 2016, this is written. Isn't this amount written there? Okay. Let's move to the following questions. So, Mr. Osoianu, to avoid In order to avoid some misunderstandings, I kindly ask you to take the facts document that you received from the Secretariat when you arrived, find it in front of you so that we avoid misunderstandings. Let's take our time. Please find it. I just want to check in my documentation as well. So, do you need time? Do you need to check your 2016 declaration? Well, if it is clear with that, yeah, we're done with the cars. We don't go back. She did not have any capital gain. And from her explanations, she sold it for as much as she purchased it for. Let's focus on the following. You have the facts that the Commission gave you when you arrived. Open it at page 6, please. It's cluster 3. There is a chart with several figures there. Now I would like to ask you the following thing. Do you agree, given that this is a public hearing, do you agree for me to read the amounts, or if you disagree, because this is about cash, especially for the last years, I will only mention it for the first years that are not that valid anymore. But for the last years, I will mention the amounts only with your permission. The Commission has the figures. I don't think we need to read them out. Please just confirm in the table in front of you. Check it, and then we will move to the next question. And the question is following. Since 2016 onwards, you and your partner declared savings in cash every year that were increasing year by year, as shown in the table below that you have in front of you. So only for 2016, we talk about 25,000 and 48,000 of euros. These are the amounts, give or take. So I will not list the next ones. The Commission asked you if you can provide an explanation about the sources of these savings. In your answer to the Commission, you explained the following about the savings you made. Namely, for 2016, you said how much is from the settlement agreement that you had with Chișinău City Hall in 2015. In 2017, you explained that you carried forward the same amount and then made some savings from your salary. In 2018, the same, you just added some amount to the savings from your salary. 2019 the same, 2020 the same, and in 2021 the same, and there was a decrease based on the fact that you had some spending. Also for 2021, you said, you mentioned an amount that your father donated, 7,000 euros. We will discuss about this. You also declared that starting with 2016, you mentioned savings made by you and your partner. You also declared that the savings of your partner are the ones of her family, meaning by her mother, father, and herself, which, as soon as because since she got the of age, she was working with her family abroad. At the request of the family, of the Commission to provide a confirmation of her income and how long she worked abroad, you did not provide any confirmation. According to the information available to the Commission, all in all, between 2012 and 2021, she, in Moldova, had a total income of around 200,000. You also declared that your concubine's mother had been working abroad in Greece since the 90s, and she's also a Greek citizen. You presented her identity card and an affidavit from her, where she stated that she's been working for some time in Greece and she transfers her income to the Republic of Moldova. However, none of this information mentioned the precise jobs, the precise income received, or other confirmation about the received income. You also indicated that she had some part-time or side jobs, that she also paid all insurance, all social contributions and things, but again, that was not, no justification was attached to prove it. Now, I would like to ask some brief questions, and then you will have a possibility to add to the facts if we missed something. First of all, please, I would like to ask you, I would like you to explain us if you agree that the declarations for 2016 to 2021, you were required to declare the cash savings of your concubine. Yes. Please confirm that the amount you declared were the ones that you really declared in all declarations. Whose? Your declarations and your annual. Whose amounts? Concubines. Concubines. The concubines' amounts are her amounts, and my amounts are my amounts. Here, during all this questioning, since we started in the round 1 and round 2 of questions and round 3 of questions, there is some confusion made in the numbers, but I stated clearly. Everything is very distinct. I have no connection with the cash of my concubine and her family. And the concubine has no connection in the sense with me, in terms of money that I have in cash and that I used in cash. These are two different things. So I had the feeling that it was a psychological testing with all this situation. And I see that here as well, it's all put together. I showed very clearly what are my amounts and what are their amounts. I didn't buy anything using their money. I purchased all on my money. They did not interact with me in any way at any stage. Do you understand? Moreover, if I'm not mistaken, and I attached it, actually, and I told when I told her last time to make customs declaration, and you have it, it should be attached. There is a customs document about declaring money when my mother-in-law crosses the border. Look at that, and there is a certificate from Patmos. I just couldn't translate it because it was urgent. On the island where she works, and where my concubine worked as well. So it's that she is employed there for official jobs. And I attached it, and I also attached information about her citizenship. I understand, Mr. Osoianu. Now let's take it one by one. But here we get things mixed up. We don't mix anything up. Yeah, but how can I confirm? I have nothing to confirm here. I repeat my question. You have the obligation to mention, to state the cash held by your concubine in the annual declarations. I mentioned it. You declared to the Commission that the cash declared for you is the one that you are responsible for and you can explain it. The cash declared for her concubine is her and her family's amount, her mother and father. So it's hers, her mother and father's. So it's accumulated for the family of your concubine. So her family means her mother and her father. Yes. And her. Now, my next question. According to the declarations you should file annually, what's your obligation to declare your concubine's cash, to declare cash of a concubine and her families, given that she is of age? Well, actually, that's the cash of my concubine and her family. And I declared, because I asked her, she told me, and I declared it. So you declared the cash belonging to your concubine, her mother, and her father. Is that right? Yes, concubine, mother, and father. It's not split in any way. There is no distinction there. I understand. Next question. According to the legislation, you are responsible for the accuracy of information you submit in the annual declarations. Of mine, yes, but it's your declaration. We were talking about it. In your declaration, you mentioned this cash. How did you verify whether this is accurate information or not? I asked her, what money do you have in cash? That's very simple, and she told me, we have these amounts. Okay, last questions about this field. The customs declaration was never submitted to the Commission. Well, I will check it, but I certainly prepared to send it. Well, if you prepared it, please do send it, but we haven't received it yet. Just I want to make sure that this is true. Secondly, in all the information you submitted, you presented about your concubine's mother, general, or they show the one that is not translated. It shows where she works, but none of those documents state what was her income, what was she receiving, or what were the social benefits that you were mentioning. There is no document showing specific numbers. Well, let's ask her. At that point, I asked for time then. I think even in discussions with you, I told that I need time, and you got it. So for what she was able to give me at that point, that's what she sent to me. Thank you. Do you have anything to comment on this? No, everything is written. I just want to... a clarification question, Mr. Osoianu. You said that when you received the land plot in Strășeni, you said you were a young person. Now we talk about concubine. So who are you? Are you a family or are you concubines? Please make clarity for the Commission. When is it true? We are a family. We are a family, but we cohabitate. So is it being concubines or young family? It's being concubines. But cohabitation does not mean not being a family. So what you declared previously to the Commission that you were married, what is this? How do we, should we take it? It's my family. Wedding is a form of family. Marriage is a form. What does this mean, that you lied to the Commission? How did I lie? So what is she? Is she your wife or is your concubine? She's concubine because we did not register a marriage agreement. There is no marriage agreement. Now, Mr. Osoianu, we will move to another cluster of questions from the same category with figures. Please look page 7 to make it easier for us. I will try to make this question shorter because, as a matter of principle, the Commission for the years 2016, 2018 and 2021 sent you some charts with all the information about your income and expenses. And in the Commission's calculations, in 2016, your expenses exceeded your income by almost 900,000 lei. In 2018 and 2021, by about 100,000 every year. The numbers were revised after the last round of questions when you provided us information about the pension, the alimony that we were paying, and there was a bit of increase for 2016, 2017. We calculated this amount based on information you provided to us, the 25% of the salary you got those years. In the information, in the tables that you received, you did not challenge any of the figures presented by the Commission. What you challenged is all numbers that the Commission presented with respect to the income, with respect to the savings and expenses made by your concubine. To be precise, you said there was the calculation was not correct, that your savings are your savings and what she was buying is hers. And namely, in 2016, your concubine purchased 2 garages for 308,000, and you said this should not be taken into account because this is hers. And then you also excluded all the savings that we showed as hers.
In 2018,
In 2018, you excluded those savings that she had. You said that they didn't have to be taken into account, and by savings we mean the cash that we've already had a discussion about a couple of minutes ago. For 2021, you also challenged those savings that were declared, and then there were real estate investments that you had nothing against. They remained as they were presented to you by the Commission. Now, I would like to ask you again if you do not disagree, if you can confirm that you did not disagree with the amounts presented in terms of salary, allowances and savings declared by you, but that you've only challenged, that you disagreed with including in the calculations the expenses and the savings of your partner. Is that correct? I made calculations on the basis of the figures that appear in the Declaration on Revenue. And I presented that to you in the last round of questions, so that was correct. Perfect, because they all match the figures of the Commission. That is correct. Be it that they coincide or not, they match or not, we can sit together with the accountant to calculate. Since January 2009, you pay 25% of your salary, of your monthly salary, as maintenance support. Is that correct? Yes. The calculations were made on the basis of the salary that you received in those years. Now, please explain the following. You maintain that all the procurements and the savings of your partner should not be taken into account when assessing your wealth. Is that correct? Yes, that's correct. Please explain us why. Because the saving in cash, their saving in cash is their savings. It cannot be taken into account for the family that I have the obligation to support, to provide for. I am providing for my family. I think this is not relevant. So why not? Because I did not spend it. I did not spend anything of what they had. You don't have joint expenditures with your partner. We have expenses and we have revenues that are enough to cover our expenses. When speaking about all the social benefits, you did not challenge that. But are they also taken together into account? Yes, where it comes to the social benefits, yes. Because that is calculated on the basis of my salary, that's where those figures came from. But when it's about procurements, can you explain to us clearly, when it comes to the procurements in 2016, give me a second, I need to be certain that I got the right year. I mean, the 2 garages that were mentioned that your partner bought, those are parking spots, not garages. So your partner needs two parking lots for herself, or is it one for her, one for you? One for me and one for her. So you are using these assets, aren't you? Sometimes I do, sometimes I don't. She's been also renting it out. So then how can you explain that this should not be taken into account when we are calculating your wealth? Well, what do you mean, how can I explain it? She's bought it, it's her property, it's not my property. It's her property. She owns it. Imagine that. Do you think if I will claim her assets as my own? So, but you do know. I mean, do you think I would? Do you mean that they are mine? I just want to have to have this confirmation with you in the third round of questions. The Commission has drawn your attention to Article 2, Paragraph 2 of the Law 26 that provides for the powers of the Commission to examine, to look not only into the candidate but also close people and to ask you questions. No, I'm just saying that I have nothing to do with that. She's bought it with the money of her family, as in her mother's money, her father's money, and with whatever savings she's had, so I do not claim those assets as mine. The difference is the disbalance for 2016 about 900,000 lei, and the imbalance for 2018, 2021. Regarding explanations and supporting documentation, there is none except of the fact that this is only money of your partner. Is that correct? I told you what I have. I've annexed that, and I explained and I presented the calculations. Understood. Now, the next round of questions, I would like you to have a look at the facts. On the next page, page 9. Wait, not that. 11, page 11. 10. Yes, 10. I hope this will make it easier and faster. So this is about a donation that you declared for 2021, a donation from your father. And you declared one donation of 7,000 euros, about 146,000 lei. Concurrently, according to the information that the Commission came in the possession of in the period of 2012-2021, your parents, both of them, your mother and your father, obtained a gross taxable income of about 77,000 lei. When asked about the source of revenues, where the 7,000 euros came from, that is, your answer was that that was obtained by your parents from agriculture, from farming, as they were producers of vegetables and fruits, and they were also retirees, and they received retirement pension. You've annexed supporting documentation with regards to the monthly pension of your parents in the amount of about 8,000 lei for every parent, for both parents. Sorry. And you also presented a certificate of producer signed by the mayor of the village where your father lives, confirming that your father owns an agricultural land plot with an area of about 0.29 hectares, and that he grows there about 1.52 tons of fruit and vegetable a year, and about 3-4 tons of fruit from the trees. And also what it says is, the certificate says that the fruit and the agricultural produce is being sold in the local markets. You did not provide any supporting documentation with regards to the actual sale or with regards to whatever revenue might have been obtained out of this occupation of your parents. Please confirm that you communicated to the Commission that that amount of 7,000 euros was acquired by your parents from farming, them being producers of fruit and vegetable while being retirees and having a retirement age pension. I confirm. And you provided supporting documentation with regards to the monthly pension of your parents, about 8,000 lei. So what I presented, that was it. I confirm. Do you confirm the revenue for that the revenue for 2012-2021 was about 77,000 lei for both parents? I don't know. I did not look into that. You checked. You said that it was like that. But you did not challenge it. You did not disagree with it when you received this information. I don't know what were their revenues. And you did not produce any document with regards to what they sell. What is the price for that at the market? Yes. You have no supporting document with regards to the sale of produce by your parents. Well, I confirm what I presented. I have nothing else in addition to that, and I explained what they did. Do you have anything to add in this regard? Only that they systematically, every year since they've been sending money. Some amounts are smaller, some are bigger, but what they have, they send for different purposes. Even now, we, for instance, picked 5 tons of pears. So please clarify, do they send you money every year? Yes, money. And did you declare that money in all your previous declarations? No, because the amounts were not such that had to be declared according to the law. Okay, thank you. And the next question has to do with the donation declared by you, one that is related to your partner, the annual declaration for 2017. And this is certain. We don't have to check this. It's certain. Don't waste your time on checking. You declared 5,000 euros. And so far, in the media, they used to say that I received this money back in 2017, that the donation was made to me, but the donation was to the partner. But you declared it in your annual declaration. And the question of the Commission was, can you provide any supporting documentation with regards to this money? How was the money transferred? When? And whether the money belonged to the mother. Where did the money take the money from? And you again repeated the same information about the mother's activity. And then you said that in the bank transfer in 2007. For that, there was no document available. Yes, there was a bank transfer. So can you confirm that you declared this donation of 5,000 euros to your partner? That the mother of the partner transferred the money to my partner? Yes, that indeed happened. She received that money from her mother. Do you confirm that this belongs to your partner? Yes, I confirm. And do you confirm that this money was transferred by the mother of the partner? Yes, I confirm. And do you confirm that you did not provide any supporting documentation with regards to this? I did not provide one because I was not given one, and I don't think I will ever, I will find it.
This is the end of the open session questions.
Very good. I think we're coming now, there are one round of additional questions, but these have been in consultation with you, have been agreed to do so in a closed session. My question to you is, because at the end of the proceedings, you always have the right to make a brief closing comment. Do you like to make that comment right now at the end of the open session, or do you like to do that at the end of the entire procedure, and then your statement is not in open session? It's up to you.
I could do it. I could do it now.
Okay.
I could do it now, or at the end, or now. Apologies, nervousness sometimes takes hold of you. I would like to say for certain, it was not one of the nice experiences. I must say, you can say that a huge amount of work was invested into this by the members of the Commission, of the Secretariat. They were very open to responding all of my requests, and I would like to thank them for this. They were understanding. There are issues. there are issues with me as a candidate. I've been saying over and over again all my life, and I still do, that I saw the mistakes that were made, and I apologize. I had another document with regards to a bank account that I closed. I didn't know about it, but the Commission brought that to my attention. I can present. Other than that, what can I say? I wish you the best of luck with the other candidates, the upcoming candidates. It's certainly not easy. It's difficult to remember, to make things right, to prepare, to provide the information. But this is the situation. The law is what it is, and we must observe the law. Thank you very much, and I wish you the best of luck, and the best of luck to everyone, actually. And I apologize from the members of the Commission if I lacked some tact at some times, or there were issues that we went into with Madam Victoria. I have all the respect for you, so I apologize for whatever misunderstanding there might have been around that car.
Thank you very much.